A common question we're getting in the office these days is, mom or dad is on the fringe. They're starting to lose capacity. They have the beginnings, stages of dementia, and they've just signed a will. And guess what? That will or that trust change doesn't benefit the children in the same way. There's been some sudden change during a time in which dad is still alive, but he has the early or even moderate signs of dementia. What can a person do? Well, if you listen to other videos that I've participated in, we've talked about the difficulty sometimes of waiting 5, 10, 15 years and then doing an undue influence case. Witnesses have moved, medical records get lost, witnesses just disappear or even die, and it's really much more difficult to prosecute these cases. So one of the hot issues for lawyers these days is, and for courts is, when can an individual that's been aggrieved by a sudden change bring that lawsuit? Well, we know under Hawaii law and the law of most states, a court-appointed conservator has typically the absolute right to undo a change that was made as a result of undue influence. Some jurisdictions now have had cases go through the courts where, upon the point of incapacity, typically it's determined by a forensic psychologist, psychiatrist, that trust typically becomes, or will becomes, irrevocable, generally speaking, and then the beneficiary can bring a claim. Obviously, you want to bring a claim sooner than later. So what's happening now in the law is the courts are starting to see these cases as people are living longer and deciding this legal issue in the various jurisdictions. When is it too early to bring a case to invalidate a will or a trust? And as I said, the safer course of action is try to get a family member appointed conservator, because that is the most direct way. But there are other ways to do that, and the courts are going through this as we speak.